On the record.
This is a matter of Zachary Coughlin, case number 06M13755. Today's date is May 8th, 2007. Today is the first day of this moral character hearing. Parties, state your appearances for the record.
Good morning, Your Honor. Susan Kagan appearing on behalf of the State Bar and the Committee of Bar Examiners.
Good morning, Your Honor. Zach Coughlin appearing on behalf of myself.
Okay, and the court's going to proceed in the following matter. There's going to be opening statements from both parties. Applicant is then going to present his case. The applicant is initially going to furnish enough evidence of good moral character to establish a case. In this case, the applicant is going to have to furnish enough evidence that he has good moral character, which would include evidence that he has addressed any alcohol abuse issues. Okay, once the applicant has made his showing of good moral character, the State Bar is going to have to present evidence to rebut that good moral character. And then the applicant is going to have to rebut the showing of bad moral character with proof of rehabilitation or an explanation for why his behavior may not indicate bad moral character. In terms of scheduling witnesses, how many witnesses are you going to have?
I believe.
And how are we going to schedule them?
Okay, most of my witnesses are scheduled for tomorrow.
Okay.
And I believe there are, at this point, 7 witnesses scheduled for tomorrow.
Okay. Tomorrow we're only going until 4 o'clock, so.
Okay. I don't think it's going to be a problem. If
Okay.
anyone is, not able to testify, they can testify on Thursday.
Okay. And Mr. Coughlin, how many witnesses do you have?
I don't have any witnesses other than myself if the court wishes to hear from me.
Okay. Well, you're going to present your case first, so do you want to start with opening statements? And you would go first because it's your burden.
Okay.
So let's start with opening statements.
Okay. Should I stand up?
Sure. Or whatever you're comfortable with.
Okay. Well, good afternoon, Your Honor. I apologize again for being late. I think I should start off by addressing what probably appears to you as a paucity or a lack of witnesses and things of that nature. I don't have any excuse for that other than to say that this process is kind of, I've gone about as far as I can go with this process. And so I'm just here to answer any questions you might have. I think you've had access to a thorough description of the issues that the State Bar was concerned with and my attempts to address those issues. And simply put, I don't think anything I've done is so bad that it should prevent me from getting a license, especially when viewed in combination with the steps I've taken to address the concerns the State Bar had. Thanks.
Do you have an opening statement?
It'll be just very brief, Your Honor. As set forth in the pretrial statement, this case is about candor and cooperation. There are Mr. Coughlin. The evidence will show that he has an inability to be candid with the State Bar in relation to its investigation and this proceeding. He, first of all, omitted things from his application, and he failed to update his application. When he did provide updates to his application, there were many misrepresentations made in those updates. And he has essentially failed to cooperate with this proceeding. And that's evidenced by his deposition testimony as well as his dealings with this court and the State Bar. And based on that, the State Bar submits that Mr. Coughlin will be unable to prove that he has a requisite good character for admission.
Okay, Mr. Coughlin, what you should do now is present your evidence of good moral character. And because you're representing yourself, you'll have to get on the stand and present your evidence of good moral character in a narrative form.
Okay.
Okay, so you're going to have to be sworn.
Should I go?
Sure, yes.
Can I bring my notes
Sure.
with me?
Oh, is there a table? Okay.
No, I know.
Yeah, okay.
Oh, Mr. Coughlin, would you please stand and raise your right hand? Do you solemnly state under penalty of perjury that the evidence that you shall give in this matter shall be the truth, the whole truth, and nothing but the truth?
I do.
Please be seated and state and spell your first and last name for the record.
My name's Zach Coughlin, Zachary Coughlin, Z-A-C-H-A-R-Y, and Coughlin, C-O-U-G-H-L-I-N.
Thank you.
Okay, you may proceed.
Good afternoon, Your Honor. To present in a narrative form why I think I should be given a license, I would start off by pointing to the issues that the State Bar has highlighted. To start, the omissions that the State Bar is pointing to are of the type that have been past case law in this state in licensing and moral character applications been viewed as so minor as to not qualify as the type of omission that reflect adversely on candor, particularly when viewed in light of the fact that I reported things of a far more serious nature, such as my dry reckless driving charge, that is. I reported the incidents at law school to the State Bar. I reported my arrest in October of 2001 to the State Bar. And from the State Bar's pretrial statement, some of the omissions in which they're taking issue with are things like, I'm quoting here, Mr. Coughlin said he was a patent attorney. He's an attorney who's also listed as a patent agent. It's unclear whether he's a patent attorney. Things of this sort, which are really overly technical, and I'm not even sure that's an omission if you look at the record thoroughly. But throughout this 5 years of interacting with the State Bar, I've been, if anything, I've been extremely candid. I don't know how many people you have come into the State Bar's informal conferences and bring up drinking as an issue, you know, who don't have a DUI, and who have never been convicted of any crime other than reckless driving, a dry reckless driving charge in January of 2003, and perhaps some minor speeding tickets along the way. Further, the State Bar has been presented with, in my estimate, somewhere in the range of over 600 signatures from recovery-based meetings. So if the issue is, recovery, you've got someone who came in, self-reported, and then went out and went to a great deal of meetings and presented documentation of that, as well as letters of support from the State Bar of Nevada's director of that bar's Lawyers Concerned for Lawyers program, an attorney mentor, and several other attorney letter of recommendations testifying to my character specifically.
Before we proceed, do you have a list of exhibits? Did we get a list of exhibits from you?
Other than what the State Bar submitted, no.
Okay, so
All of them.
these attorney mentor letters, where are they?
They're included within the State Bar's.
Okay.
Pretty much everything I would have submitted as an exhibit has been covered by the State
So
Bar's.
you don't have any exhibits? Okay.
No, other than what I would be able to use out of the State Bar's.
Okay. Okay. I mean, what I need is evidence of good moral character. Okay?
I see, Your Honor. I would point to, as evidence of good moral character, included in that is one's attempts at rehabilitation, as I understand the law. And in addition to the what would be contained in Exhibit 3, wherein I did an update to my moral character application, which is followed by approximately 45 pages of signatures from AA meetings over from early 2003 to the present day. These were done at just voluntarily on my part, for the most part, other than a 6-month period in which the lab program had directed me to attend one meeting a day for 180 days in a row, or one recovery activity. But that's an hour a signature. And so I think that, to me, illustrates a great deal of time and effort that's been put into this, which I don't know if can really be summed up in words, but hopefully this number of signatures and the number of pages that have been submitted can make some impression. Additionally, there's a letter from Co. Swobe. Give me 1 second, please. Exhibit 40 contains letters of reference from a number of attorneys, in addition to Mr. Swobe. I apologize. That's actually Exhibit 39.
Your Honor, I'm sorry. I'm going to object to any reference to letters of recommendation in this matter on the basis that the State Bar never agreed to have character witnesses by declaration or by letter. And
So the objection is hearsay?
exactly.
Okay, sustained.
Your Honor, if it's a trial exhibit, does that mean it's part of the trial and it's to be considered by the court, or?
It depends on if they're admitted into evidence. I don't know what's going to be admitted into evidence. What I would suggest is that you tell the court in your own words why you think you're a person of good moral character, what volunteer work you've done. I mean, just give us why you think you're a person of good moral character.
Okay.
And why you should be admitted. And you can refer to some of the exhibits. Some of them may come in, some of them may not. But that should have been worked out with you in terms of a declaration with the State Bar, in terms of whether they would accept declarations from people that you were a person of good moral character. And in general, they accept declarations, but you have to work that out ahead of time, because otherwise it's all hearsay.
Mm-hmm. All right.
Okay.
Well, then, I would refer to those letters. I know you've sustained the objection, so I don't know to what extent I can still refer to them, but they are included in the State Bar's exhibits. There's a letter from a Reno District Court Judge, John Cadlick, in there. There's letters from attorneys that I've worked for, the Johnson Hannon firm, the Morris Sheeta firm.
I'm going to object to this
The
on the
problem
basis
is,
of relevance.
it is hearsay, and what you need to, I mean, the problem is these people, there should have been declarations, or they should come in here and testify.
Okay.
I mean, I can tell you generally in moral character trials, what you do is you have 8 or 9 witnesses come in and say that you're a good moral character and that you should be admitted, and they give examples of what things that you've done that would indicate that you're a good moral character.
Mm-hmm.
And you can do it, I mean, if you don't have other witnesses, of course you can do it yourself, as you can start testifying to why you believe you are of good moral character.
Okay. Well, I think I'm a good moral character because I've graduated from schools. I've graduated from college, graduated from law school. I passed 3 bar exams, and I've never been convicted of a crime other than a dry, reckless driving charge. I self-reported that perhaps alcohol was an issue to the State Bar, which to me is presumptive evidence of good moral character. I don't know how many people you get to do that a year, but certainly if that's not looked upon with some degree of seen as exhibiting some candor or cooperation, then I think that sets a dangerous precedent for those in the future who might be thinking about self-reporting or taking a look at their drinking. I think it creates a climate of distrust and fear and secrecy with the State Bar. If you got a guy who came in, never was arrested for anything other than a dry, reckless driving charge, and said to the State Bar, I think I have a problem with drinking, I'm taking a look at it, went out and on his own, at his own direction, collected upwards of 600 AA signatures from 1-hour AA meetings, submitted a bunch of letters from different AA attorneys in Nevada, attorneys in Nevada who have been active in an AA and on the Nevada State Bars, substance abuse chapter for years and years, and letters from district court judges.
Objection, hearsay.
I'm going to overrule the objection because he hasn't really gone into details about what they've said. Do you do any type of volunteer work? I mean, what do you do?
Well, in AA, I do volunteer. I make coffee. I've held commitments in AA where I get up before the meeting, make the coffee for the meeting. I have people in my life who have started going. I've taken them to AA meetings, and they've started getting sober because in some way I think I helped that to some extent by taking them to a meeting. In some way, I think just being here is a bit of a service that I'm doing, because this isn't a comfortable situation for me, and probably there's not a whole lot for me to gain out of this, but I believe I have strong feelings about the way this situation has gone and the way my particular case has been handled, and I think it deserves some it deserves to have a look taken at it to see if perhaps there are some issues here that we need to be concerned with in terms of the policy that's set forth. If this court and the bar is to look at those who self-report and go on to treat them in the way that my case has been treated and what the ramifications of that will be. In addition, I think there's some issues to look at in terms of the lab program and how it deals with individuals who present with either some sort of ADA issue or some sort of condition or health problem that maybe takes them out of the realm of their typical participant, one who maybe is just a garden variety alcoholic. But how does the lab program treat those who present with ADD or who present with back pain or who present with diabetes or something that complicates the matter? And is the lab program being respectful of that person's doctor-patient relationship? Is it trying to commandeer that relationship? And does the lab program and the state bar discriminate against individuals who maybe have had to take certain medications that the lab program would rather them not be taking?
I think what you should do is address the issues of the honesty, fairness, trustworthiness. Those are issues that this court's concerned with.
Okay.
And present through your own testimony evidence that you're trustworthy, that there's honesty, candor, those issues.
Okay. Well, to go back to something like in high school, I was an all-state basketball player 3 times, and I was a captain of the team and things like that, and never missed a practice, and developed a good relationship with a group of people in that way, and I think was someone who was doing something to be productive with their life. From there I went on to college and then law school, and basically was just a student, you know. And, I think something that's really illustrative of my candor and trustworthiness is the self-reporting to the State Bar that I mentioned earlier. In addition to the prompt reporting of my dry reckless arrest, and of the movie theater arrest, and of the law school paper matter. This isn't a case of someone who got arrested and didn't report it to the State Bar. You know, these are situations where I promptly reported these things to the State Bar. And just the determination to face the adversity of, you know, graduating from law school and passing bar exams and then not being licensed, and going from the time I passed, you know, the Nevada bar to actually getting licensed was well over 3.5 years, you know. So just hanging in there, trying to stay active in the legal community, which was not very easy. I think most people who are trying to work in the law, who don't have a law license, but have passed the bar, would say that it can be difficult to find a good position in a firm given the economics of law practice these days and the state of the economy in those years that I'm speaking of, which was roughly 01 to 04. And so I think that illustrates a lot of character, in that I stayed persistent. I stuck with it. I had to do something to get the Nevada bar to license me, because from my experience, they don't take that lightly at all. And, you know, it took a lot, I think, to convince the powers that be in Nevada that I should get a law license. And I think that's something that perhaps this state, this court, this bar could consider, you know, and give some weight to, especially considering that I was in Nevada for this last, for the better part of my life. I've only lived in California for something around 2 months. And so it's those in Nevada who have had the opportunity to observe me and make judgments about my fitness to practice law.
Okay, so for the record, what you need to do is establish, because it's not on the record, that you're a Nevada lawyer, that you have proven to the state of Nevada that you have good character by definition, that you're, I mean, you have to present evidence, because I'm not hearing it now. I mean, I can presume you're a Nevada lawyer because I have all the papers, but it's not in the record. You've got to do that.
Okay. Well, can I state under oath that I am a Nevada lawyer?
Of course. That's what you're there for.
Okay.
What you're here for.
Okay.
I mean, what you have to do is prove that you have good moral character. And you have to give us proof. So you have to set it up so that it's in evidence.
Okay. Well, I'm a Nevada lawyer. I'm also, I have passed the patent bar exam, the U.S. Patent and Trademark Office's bar exam, and been licensed with that office.
Was there a moral character component to getting the license for Nevada? Was there a moral character component in getting a license to be a patent attorney? These are the things we need to hear.
Yes, there were.
Okay, so
yes, there was in both
go
cases.
Ahead.
There was a thorough process in both the patent bars, licensing application, and moral character application in the Nevada bars. I was given the license as a patent agent prior to becoming an attorney, And